Well, the state of Florida is making its case for why it shouldn't comply with a court order to make changes at the immigration detention facility known as Alligator Alcatraz. WPTV's chief investigator Jamie Ostroff has been on top of the legal battle surrounding the facility that's cost taxpayers hundreds of millions of dollars. Jamie joins me in the studio to break down the state's latest defense of the controversial camp. Jamie?
Yeah, Todd, this is the civil rights case where the ACLU is arguing the First Amendment rights of the detainees are being violated because they cannot talk to their lawyers in a timely and confidential manner. So about a month ago, a federal judge did agree, in part at least, with the ACLU. She ordered the facility to add confidential phone lines, post signage about access to counsel policies, and also post those policies in more detail online. Now, the state has said it plans to appeal, and they just this week asked the same judge to pause her order while they prepare that appeal, and the appeal is pending. So they argue that the facility already allows for confidential access to counsel via in-person visits and Zoom calls. And regarding the posting of policies, the state says, well, that's government speech, and the court doesn't have the authority to compel government speech. They also say installing phones in the middle of the Everglades would just be too costly to be feasible. I asked the lead attorney for her take on the state's pushback.
And some of the things in that March 27th order are things that the state and ICE had testified under oath that they were already doing, which beggars the question, well, if you were doing this all along, then why are you appealing it? And why are you saying, oh, we can't comply with an order telling us what we were saying we were doing all along?
The state also referenced an appeals court opinion from earlier this week to argue that a court doesn't have the authority to dictate how a detention facility is run.